Good evening, everybody. It's Wednesday, so that means I'm welcoming you to another episode of Chaz Calenda, Attorney at Law, here on the Coalition Radio Network. I'm your host again, Chaz Calenda, attorney at the law firm of Inman and Torgy in Coventry, Rhode Island. And as usual, I'll be walking us through the show tonight. And most importantly, we'll always be keeping the law above politics. We're continuing this series where we touch on various legal topics here in Rhode Island and nationally. Tonight, we're going to discuss small claims court here in Rhode Island. What kind of cases are heard there? What are the rules and procedure, and exactly what does it work, and how does it work? To help me discuss this throughout the episode tonight is Coalition Radio host and station management, as he will often refer to himself, Pat Ford. Pat, as always, I appreciate you joining me tonight.
No, looking forward to this. This is what's great about this series is we following in a sense the news cycle to a degree. And we're going to morph from last week's high level conversation with a constitutional lawyer and regarding SCOTUS and decisions and issues of great import, and we're going to go to a local set of issues of great import, and that's eliminating, if you will, the urban legends, the misconceptions, the unknowns about a very powerful legal system within the system that was, in my opinion, and I'd love to you fill us in a little bit more about the history, but which is a great resource for the individual here in this state for small business issues, for those situations when the individual might feel a little railroaded or priced out of the big legal system. And that's, of course, the small claims court.
Absolutely. And the small claims court was designed to take care of smaller claims, particularly ones based in contract or retail sale. So maybe a dispute with a business provider or a service. And they are limited to claims that have damage claims, money claims, in other words, of $2,500 or less. That doesn't include your court costs or potential interest or anything else you might earn on top of those damages. But the damages themselves, the claim has to be $2,500 or less. And it's actually a division of the Rhode Island District Court, which is a court of limited jurisdiction here in Rhode Island. It has very particular claims it can hear, and it has I would say it's a pretty small level of jurisdiction. Inside that is the small claims court, where you can bring these claims. And they also have the regular civil court, because that's what small claims is. These are civil claims. They have the civil court, which usually takes a little bit longer. It costs a little bit more, and the rules are a little bit more formal. But they designed the small claims division to be a little less formal, hopefully helping people to get through the process quicker without the expense and maybe a headache of having an attorney with them or against them, and to design to come to a quick resolution.
Now, a quick question, and I'm going to make an assumption that in every individual state there are different flavors of rules, regulations, as dictated probably by state law.
That's right. It's either by state law or it's by the rules of the court for which the small claims would lie.
Okay. So it's important. We get folks from different parts of the country listening to understand that while the general concepts may be in place, if you will, for your jurisdiction, that the rules that we're talking about tonight are going to be specific to the great state of Rhode Island, the ocean state, where, as we like to say on the Coalition Radio Network, in the halls of justice, justice is usually found in the halls. But take it away, Barrister, and let us give us the 411 on small claims, because I think it's fair to say that in Rhode Island we exist in a fairly litigious society. I'll just leave it at that.
I would have to agree with you that, you can find somebody, probably at least 2 to 3 people probably call my office a day looking to sue somebody. And it could be something as benign as, I lent that guy $200. He didn't pay me back. I want my money back. So they call my office, and I usually tell them, it's probably not worth you paying what I'm going to have to charge you to go to court. So why don't you try small claims? And small claims might be able to get you a resolution a lot faster and a lot cheaper than it would be to file a suit, or perhaps go break the guy's legs and then you find yourself in criminal court. But that's a different story altogether. But the small claims court has made it so that the general rules of the district court civil procedure are generally relaxed. You don't have to follow the rule to the T as they would hold lawyers to, or they would hold even self-represented litigants to if you were to file under the normal rules of civil procedure. And that way, they think that you're going to be able to handle the matter by yourself. But there are some big caveats that go with that. If you are going to go the small claim routes, you got to know the risks that you're taking if you're a plaintiff. You got to know the risk you're taking if you have to deal with the risks that you're taking if you're a defendant, and kind of know exactly where to file everything, how to get people served, how to get documents served, and make sure you follow with the very basic rules, because otherwise, your case, no matter if it's small claims or not, is not going anywhere.
Is there a history to this court? I mean, what from what precedents or what, if you will, Western law practices did this style of court generate?
It's been around for as long as I can think of, Pat. I mean, probably, at least definitely a 20th, or, mid to 20th century type of situation. But it really came about to dispense what they call speedy and final justice. Unlike a traditional civil case that you would file a complaint, you have 20 days to get an answer to before anything can happen from the person you're filing the complaint against, and then nothing happens at that point until somebody makes a move. Here in Rhode Island, you file a complaint, and there's a pre-typed form, which if we can bring that up at some point, we can show the people it's available on the Rhode Island judiciary website. But they actually provide you with a complaint form that you as a litigant can file with the clerk's office, and they will actually, here it is right now, actually kind of give you the outline of what you have to claim and what you have to show in your complaint if you are going to go forward in the small claims court. And I don't know if you can see it there, but there is a part, if you are a plaintiff in a small claims court, on the right side there on page 2, there's a waiver of that right of appeal. And we'll talk about that in a minute, but that's very important. When you sign this document as a plaintiff, you lose your right to appeal if you lose your case. So I definitely want to get into that, because that's not something that happens in general civil litigation. But they try to make it as easy as possible for you. They try to make it as clear cut, language kind of dumbed down a little bit, and made it so that you really don't need to have a lawyer do this for you, as long as you can basically understand basic rules.
So let's start from the beginning. What, from your experience, what is the type of complaint that you'll see argued in small claims?
It's usually about somebody owing somebody else money, or perhaps it's somebody who has a dispute with the business. They paid money for something, they didn't get the service they thought they were going to get, or they didn't get the product they thought they were going to get, and somebody files suit. So those are I would say between 90 to 95% of the cases you're going to see in the small claims court. You cannot bring an action in small claims court that is not seeking money damages. So things like equitable remedies, like specific performance, any kind of equitable remedy is not available in the district court in general, unless you're in an eviction case. The district court does not have general equitable jurisdiction, unlike the superior court, except in the case of landlord-tenant law.
Interesting.
So yeah,
I would say, so the first steps then are understanding that your complaint is going to be all about money damages or money owed. Or I should say, do damages as a result of action or inaction, is that part of the small claims court structure?
Well, it is to a certain extent, as long as they're not related to personal injury cases or cases that come out of an automobile type of accident, then yes. But those types of cases are specifically excluded from personal injury cases. So To initiate a personal injury, from small claims cases. To initiate a small claims case, you need to file the complaint. There are usually exhibits or what we call, document. You could be documents that you would file with your complaint that show, why you have this complaint. Perhaps they prove your case, or perhaps they are circumstantial evidence of why you have a case. You pay the court filing fee, which is less money than the typical filing fee. And right now, the filing fee for the court is $75.75, as opposed to the $100.75 it costs to file in the district court in a typical civil case. And you have to have the complaint, any exhibits, the language assistance forms, of which there are 4, English being one of the language, and there are 3 other languages that have to go along with that. And you have to file that along with a summons that the clerk's office will generate for you. And you file that and you serve that upon the party that you intend to sue. And service usually has to be made by personal service, which means that you have a constable or a disinterested party or sheriff actually hand it to the person, or bring it to them in their usual home or place of business, have them sign for it. They bring it back to you. You file that with the court to show that there was proof of service, and that will initiate the case.
Is an attorney allowed to represent in small claims court?
Yes, and in fact, in some cases they have to. In a case where a corporation is a defendant, or a corporation is a plaintiff, an attorney must represent that party. A corporation cannot represent itself in any sort of action without an attorney. So yes, there are attorneys allowed to do it, and I would suggest that many attorneys probably don't like doing it, simply because the procedure is so informal, and self-represented litigants tend to get a lot more leeway from the judges than the attorney's going to get. And there's not a lot of money at stake. There's not a lot of there's not a lot of sexy issues as that you might find in the Superior Court or in larger civil cases that you might find. So you'll usually see small claims cases being fought and battled between 2 self-represented litigants.
Right, and the ultimate product of a decision in small claims court, is it typically an executable judgment?
It is. There is an appeal period. If you get a judgment in your favor in the small claims court, assuming you are the plaintiff, you have now an enforceable judgment once the appeals period runs, and the appeals period is usually 2 days. The appeals period.
That's not much.
No, well, in small claims, it's different than it is in an eviction case. So every judgment of the district court, and I should start with this, every judgment of the district court is appealable for a new trial, whether it's civil, criminal, small claims. It's appealable for a new trial. They call it trial de novo in the Superior Court. So let's say I file suit against you in small claims court, judge rules in my favor. You have the right to file an appeal to the Superior Court, and we start all over again. And it's like the district court case never happened.
Right, but how long is that appeal period? How many days are you getting?
I believe it's 2 days in the small claims period.
Because if you're not on top of it, you get served, and you're just a hot mess, and you don't go to court that day, or you lose. You've got to be all over this, don't you? I mean, as a respondent.
You do, because if you don't answer, so you're served with a complaint, you are expected to answer before your court date, which is, again, another difference in this small claims and typical civil procedure. Usually you get served with a complaint, you get 20 days to answer, and then kind of nothing happens until somebody files for discovery, looks for, some sort of motion or something along those lines. In small claims, when the court generates a summons, it has a trial date on it. So you're given a trial date from the very beginning, which is an attempt to speed everything up. So you can file your answer, or you can just go to court on your trial date and file that answer. And then the court will either hear your case that day, will attempt to pawn you off on mediators who will attempt to mediate your case to a settlement or resolution. And that happens quite often because the judges are very busy and the courts are very busy. They don't want to hear nor have time to hear all the cases that are being filed. And that will be the day that your case is heard. But so usually what happens is if you don't answer or you don't show up to your trial date, a default judgment will enter against you. You still can appeal in that 2-day period, but then you have to take it upon yourself to get to court and file that with the clerk's office. But what generally happens is if you do show up to your court date and or file an answer and judgment is rendered against you by the district court in small claims, you stand there in front of the judge and hand them a piece of paper and says, I take an appeal to the Superior Court, and there's the appeal process right there.
So the appeal then actually moves you up a league in terms of the court?
Yes, you move directly to the Superior Court where the action starts all over. So the complaint will be filed, a new summons will be issued in the Superior Court, and then at that point, the rules of Superior Court civil procedure take over, and it's no longer a case where the small claims rules will be in effect. It's a much more formal process. It's like any other lawsuit that you would go to in the Superior Court, and I would highly recommend you get a lawyer involved when you get to that point.
Right. So what is the procedure? You've got a complaint, you file. You said it's a $75 fee to file, certainly affordable. Talk about the rules of evidence, and actually, if you might, talk about the actual process, what happens that day in court.
So, the rules of evidence are in effect. Those rules are not relaxed. Rhode Island has a uniform set of rules of evidence that apply in every single court in the state, whether it's the district, superior, workers' comp, whatever it is. So those rules are there. You have to make out a cognizable claim. So you have to have something that is recognized as a claim under the law. So they're usually called book accounts. If you owe somebody money, or maybe you didn't pay a store or a credit card, the amount of money that you owe them, and it's $2,500 or less. That's usually what they call a book account or a contract account, or it's a breach of contract. You have to kind of spell that out in your complaint, and you got to be able to prove that. And in a civil case, which is what this is, even though it's small claims, you have to prove that by a preponderance of the evidence, and that simply means 50% plus 1. So just a little bit more than, is it more likely than not that what you're saying is true and what the other party is saying is not true. So assuming you have followed the procedure to file a complaint properly, have it served properly, which in addition to the court fees, you have to pay a constable or sheriff to serve that, which usually costs around $35 to $45, and get that returned. And assuming you followed all those procedures and file the right papers, you are able to make that argument in court and introduce the evidence that you have, if any, into court, as long as you can lay the proper foundation for that evidence.
Now, is employment claims, labor, wage claims, are those permissible in this court?
Not in the small claims court, no.
Okay. All right. So if it's related to
those
employment,
would have to, those generally are under a special statute. Employment law is a fairly complex area of law, not only in state level but on the federal level, and those will generally go to the civil calendar. You'll see a lot more of those in the Superior Court than you will in the district court.
Now, at the small claims court, how much of it becomes a he said, she said, he said? Is there an element to that?
You'll see that a lot more in the small claims court because, a lot of times you're not having attorneys involved in this, and litigants don't know how to necessarily use the rules of evidence to authenticate documents, introduce tangible evidence into evidence, and get it admitted as a full exhibit for the court to consider. In the district court, there are no juries. It's all tried before a judge of the district court. So the judges may help you out a little bit if you don't have an attorney, tell you, ask you questions to try to help you get that evidence authenticated. But a lot of it is, we met on such and such a day. We had an agreement. He or she didn't follow that agreement, and I'm out such and such amount of money. And then the judge will say, well, what do you have to say about that? And it's a very informal process, like I was saying before. And it's one of those things where it's good to get these things in writing. And if you can file an answer, if you've been sued in small claims court, and you can file an answer on the form that the courts do provide to you, then you've at least got it in writing. It's at least part of the record, and it's something that the judge can consider. And that's something that I think the court also provides to you on its website. If we have a copy of that to show our audience, the small claims notice of suit answer, you can actually fill that out and give your answer on that, and you can talk about all the different ways that you're going to answer, which is basically I deny it, or I disagree with the claim because you can see on the first page, my answer is you admit that you owe, but I need more time to pay for the following reasons. And then the other one, you can also file a counterclaim, which makes you also a type of plaintiff. A counterclaim is when you've been sued, you in exchange not only probably deny that the facts of the original suit, but you bring your own related claim to that court to countersue the original plaintiff for money that you say they owe you. And you can raise that in your answer, and you have to raise that in your answer, or else you waive it.
Wow. So there can be a fair amount of drama in these cases, aren't there? There's a lot of personal emotions often at stake.
Oh, these are drama personified, Pat. The small claims court is what I would probably equate to Judge Judy on TV, as far as the behavior of everybody, including the judges and court staff and litigants in that courtroom.
Right. So, if, for example, it was for money owed, then clearly the complainant, the plaintiff needs to show up with something written. There's which is the importance of a promissory note, isn't it?
Sure. I mean, it doesn't always have to be written. An oral contract is usually just as good as a written contract, especially when it comes to money, depending on the circumstances. You could also bring in live witnesses who will testify and say, I was present when Pat and Chaz entered into this contract. Pat promised to pay Chaz $1,500, and I saw them shake hands. Everything was good. I saw them exchange money, and or I saw them write, whatever it was, and you can have live witnesses testimony in exchange or instead of written documents.
All right, so you bring in a live. All right, so let's just say you and your partner and your business partner borrow money. That's the most straightforward case, because the next area we're going to talk about is performance of a service. You bring in someone who is a witness to it. Is that sworn testimony and under threat of perjury?
It is, because when you testify in court, first thing the clerk is going to do, or in the district court, the judge is going to do, is say, raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth, so help you God. And that's under the penalties of perjury, which if you commit perjury, that basically means you are lying to the court under oath, and that is punishable by up to 20 years in prison as a felony in Rhode Island.
Right, which is clearly an eye-opener. I mean, do you get the sense from your experience that when people get to court, all of a sudden they realize, or maybe it's then they have that epiphany of how serious a situation it is, that may have started as an argument or a misunderstanding, and now all of a sudden realize that they're in a court of law with sworn testimony and money's at stake, and is that when it usually happens?
I like it when I see that happen, because it does happen on occasion. It's less, in my experience, at least I'm going to say, in my experience, it's less likely to happen in a small claim setting because it is so informal. You usually see what you're talking about when you get to the superior court, when you have juries impaneled. You have you have 6 people in a civil jury sitting there watching you. You have a much more impressive courtroom, I will say, in the Superior Court. It's a much more intimidating experience there. But you do see it in the small claims court, because now you have to come in, and sometimes you think you got a great case, you think you're going to be able to come in there and just tell your side of the story. The other person gets up there and says their side of the story, and the judge says, all right, I believe you, judgment in your favor, that's the end of it. But sometimes the judge is going to say to you, what evidence do you have to prove this, or question your testimony or your witness's testimony? And then it becomes a situation like you're talking about, where it's like, oh no, I actually have to prove my case. If I'm the plaintiff, I actually have to have evidence that backs this up, because otherwise it really is hard for the fact finder to determine, is there a case here, who's telling the truth, and how does the fact finder go about doing that?
Wow. So, when it comes to the performance of a service, I would imagine, a loan, hopefully there's a promissory note, hopefully there's something in writing, and then it's up to the defendant to prove whether or not they paid it. I would imagine it's most straightforward. Now, where you often see, and this is the case, you've got a situation with a contractor. Now, are cases, disputes involving contractors of the statutory amount or less, are they appropriate for this setting?
Sure, it could be. Yeah, sure. Certainly, if it's within the statutory limit, you can say that, I hired a contractor, or a contract. A contractor can say, I was contracted to do a certain service. I expected to be paid for this service. Here's our agreement, and I wasn't paid. Certainly, that would fall within the small claims purview, as long as the claim is for $2,500 or less.
Right. Do you ever find people entering small claims simply because, while their actual claim might be larger, they simply go to small claims in the hope that they get something back with minimal investment?
You see it, but usually it comes out that that's the case, and there's actually a larger sum at case, and then it turns around that the court starts questioning its jurisdiction in the small claims court, so they may have you refile it as a straight civil action. But
Right.
Sometimes people, if you don't have a written document, you can't prove necessarily how much you're owed, and it may be more than $2,500, but you seek the maximum amount because that's about all you think you might be able to prove. Certainly, I've seen that happen plenty of times.
Right. Now, can you seek any sort of damages in small claims court?
Well, damages are money damages. So
Right.
damages, when I say damages, that's money.
Right.
Damages are as opposed to equitable remedies like injunctions, or like restraining orders, those types of things.
Right. So let's just say you have a situation where someone promised a service, they didn't perform it, and you had two issues at stake. Maybe they were given a deposit up front, or maybe they were paid for it already, and there was non-performance. And there were, because of the non-performance, say a business couldn't be open or open, and there's realized economic hardship as a result of that. Could that be considered part of the case?
It sounds to me like that would be unlikely to fall within the jurisdiction of a small claims case, because I think that you're going to be in a situation where that's going to exceed the limit of the damages that you're going to be able to collect. If you're talking about a business that's not going to be able to open, you're probably well outside that limit of
Right.
$2,500 at that point.
And
So you're probably going to end up in a straight civil situation.
right. Now, let's say you win your case. Are you able to then collect the filing fee and/or any court costs back from the, if you will, the defendant who has lost?
Yes, if you ask for it. So you are able to collect generally, as a general rule, if you ask for it, you are able to collect your court costs, which include the court filing fee and any service fees and anything you had to pay the court to get your case heard, or to bring if you had to subpoena witnesses, if you had to subpoena documents. You can collect that back. Can you now, if you had an attorney, can you collect an attorney's fee? Probably not. Most of the time, attorney's fees are not collectible by the prevailing party unless it's a breach of contract case, in which
Mm-hmm.
case there is a specific statute that allows you to collect your attorney's fees, reasonable attorney's fees. They always have to be reasonable,
Right.
and you can ask for it, but it's not always going to be granted to you.
And so and is that, by the way, is that part of the statutory 2,500? I mean, is that those court costs limited to that? In other words, say you've got a case where, well, I'm just being silly here for a second, but this kind of stuff happens, $2,500, and then you've got your court costs. So are they on top of the $2,500?
Yes. So
Okay.
your damages are limited to $2,500. So the damages you actually suffered as a result of the action or inaction of the other party are limited at $2,500. But then you can also collect your court costs, and if you're lucky enough, you can collect your attorney's fees.
Wow. And so you have to ask, though, for those when you file?
At least when you file, but you can also make your pitch to the judge at the time of what would be a closing argument or a brief, final demand for judgment at the end of your case. You can say to the judge, Your Honor, I would, respectfully request the court award, enter judgment in my favor for $2,500 in damages plus court costs of, $135, which you break down for the judge. These are my filing fees, these are my service fees, this is what I had to pay for a subpoena for a witness, and then reasonable, if it's a contract case, reasonable attorney's fees, which your attorney would submit an affidavit to outline what those are, and then you would agree that those were reasonable.
Wow. So it's simple but complex. I mean, there are certainly nuances to this. And I guess the challenge is the minute you consult a lawyer, well, that's why I wanted to do this show, because quite frankly, the minute you engage a lawyer, then you're going to see a great deal of your claim potentially lost to those legal fees. And you've always got that sort of calculus that has to take place. If somehow folks can walk away from the outrage they might feel, or what's the term when they're in high dudgeon, they've got to have a non-emotional, frank assessment of costs versus likelihood of success versus what their final claim can be. And that's why a show like this is so important, because you're laying out for folks really what your strategy has got to be. Now, this is part, as you said, is the court itself is part of the district court system. It's not a municipal court. Am I correct in that?
That is correct. The small claims division is part of the district court, which is not a municipal court. The district court is one of the statewide courts.
Right. So in the case of Rhode Island, where would a guy from Westerly file, and where would a guy from, if you will, a guy from CF, where would he file, he or she?
So since the district court essentially has 4 different divisions at this point, they used to have, I think, up to 8, but I think they have 4 left. So if you're from Westerly, and the other person may not have to be from Westerly, but let's just say the agreement took place in Westerly, you would file on the 4th Division District Court, which is located in Wakefield.
Mm-hmm.
A guy who's probably in Providence, if the event, an event took place in Providence where everybody is, you as the plaintiff can file in the 6th Division District Court, which is located at the Garrahy Complex in Providence. If Newport County is the 2nd division, so you have plaintiff there, and then there's one more division, which I'm trying to think which ones we went through already, but there's the 3rd division, Kent County. So Warwick, East Greenwich, West Warwick, they would file in the Kent County District Court 3rd division.
Excellent. Now, critical point, and that you just raised. Do you file where the folks are residents of, or do you file where the event took place?
So, if you're both residents of Rhode Island and the claim was, the claim essentially could have been done anywhere, could have been happened anywhere. The plaintiff can generally file where the plaintiff resides, so long as it's not an undue hardship for the defendant. And Rhode Island is so small, it's probably not going to be an undue hardship for the defendant.
Right.
So, where it comes into play is we have an out-of-state defendant,
Mm-hmm.
and and something may have happened out of state. But you're a resident of Rhode Island, and Rhode Island may have some interest. It all comes down to personal jurisdiction at that point. But many times there are situations where you have to file in the 6th Division District Court, which is Providence, because that's what the rules say in a particular situation.
Now, did you mention out of state? If someone, because Rhode Island is so small, someone in Providence gets into a financial dispute with someone in North Attleboro, as we call it. If you're the plaintiff and you are owed money, allegedly, as I say, by the guy from North Attleboro, where does that take place in Providence, and how do you? Because it's again, I have to say this at least once every time I'm on with you. I am not an expert. I attended the, if you will, the television school of law. And I just play one on the radio, if you will. So these are all the kind of minutia that blows up a case. It strikes me, just as a casual observer, that more often jurisdictional issues have more to do with failed cases than the actual cases. Is that a fair statement?
Sure. Jurisdiction certainly can muck things up and muddy the waters, and so can procedure. And I see most of the cases that fail, that would otherwise probably succeed, fail on one of those two grounds. But to get to your hypothetical, that you got a guy from Providence who says he's owed money from someone from North Attleboro. It depends. It's really going to depend on which state in that case has the greater interest in vindicating its own laws. So I might be from Providence, but if I went to North Attleboro and signed that document, I probably have to go up to North Attleboro, the court that covers North Attleboro, and file my claim. However, if everything was done in Providence, even though the other person is not a resident of Rhode Island, they would be likely be subject to the jurisdiction of the Rhode Island District Court, the 6th Division District Court, so I could file my claim in Providence in the 6th Division. It's just now a matter of how do you get the court to assert its jurisdiction over that person, because you can serve an out-of-state defendant. You can do it by under Rule 4, where you can send a certified copy. You send the complaint by certified mail, return receipt requested, and then file an affidavit of compliance with the court to prove that you actually served them. And then they have the time to respond or show up in court. If you do so, the court can assert its jurisdiction over them and enter judgment in your favor. And then enforcing upon that judgment is the tricky part. And I think that's what you were getting at when you brought up that hypothetical.
Right, and that is a natural segue into the next step. You've had your Perry Mason moment. You've had your Law and Order moment. Cue the sound effects, right? You've won your case. Al Pacino is in the background screaming, the whole world's gone crazy, right? You just that glow of victory is among you. You stand in front of the people in the people's court, victorious. Now you got to collect the money. That's right. Where it gets really interesting, right? So you win that day. The judge executes a judgment, I would assume, on the spot. Is that what happens?
Yes, it's almost always a judge will pronounce judgment the day of your trial, but sometimes they want to research an issue and they'll get back to you after a couple of weeks.
Right. All right. So let's go with you walk out of that court that afternoon, that judgment clutched in your hands, the ink running down your shoulders. You remain victorious. How do you know? And let's just take a round number. Mama Luke, in the words of the immortal philosopher Ricky Ricardo, owes you 2 gee whizzes. Okay, so you got again, as they say in the Blackstone Valley, he owes you $2,000. So how do you get your $2,000? I'm assuming the fine person who took you all the way through this isn't going to say, okay, you won, here's your money. how in reality, how does it work both for a claim within within Rhode Island, say, for example, and our hypothetical case for that fine folks in North Attleboro who have got the do-re-mi?
Well, you're absolutely right. And there very rarely, if ever, do I see a judgment paid immediately after being rendered. Usually have to go into what they call supplemental proceedings.
Mm-hmm.
And at that point, after the appeal period is ended, you file for a writ of execution, which is basically another document that has to be served upon that person. Let's just say in this case they're both Rhode Island residents, so you have the writ of execution issued by the court. The execution is served upon the person upon who the judgment has been ordered against. That person either satisfies the judgment or the execution is returned unsatisfied. If the execution is returned unsatisfied, a citation and supplementary proceedings is ordered. That person is given a court date, and they have to provide the court a reason why they can't satisfy that judgment. And if the court will usually sort of maybe get in the middle and try to arrange some sort of payment plan that becomes an order of the court. It says, I'll pay $50 a month for the next 25 years or whatever it is. And as long as you do that, you're not going to, there's no more further proceedings. If they don't do that, if they don't abide by that, or they can't come to an agreement, there are other tools at your disposal. If they have assets, you can file a writ of attachment to someone's bank account. You can file a lien on their home if they own their home. You can garnish their wages if you file the paperwork right. And those things can be done after the final judgment is entered. It becomes a lot more tricky to collect the judgment when the other person is not a resident of Rhode Island and or would be normally subject to the jurisdiction of Rhode Island courts.
Yeah, and it can be interesting and amusing. Anecdotally, there was a case several years ago where someone, and this is back in the days of the much beloved Fleet Bank. I say that with a wry smile. I don't know anyone who loved Fleet Bank. I had a customer of mine who Fleet Bank returned several checks on because the money hadn't been in the account for 2 or 3 days. And so when I went to the said branch of Fleet Bank, I said, "Do you remember the movie It's a Wonderful Life? Do you remember the banker in that?" And she smiled and said, "Yeah, what a wonderful guy." And he go, "No, you're Mr. Potter." All right. At which point she, the point was made. But it was hysterical for so many people because someone filed a small claims court against. Was it a small claims court? Or maybe it was a district court. Anyway, the Fleet Bank, the respondent failed to appear at court, and a judgment was made. And and somehow this missed the high-paid salons at Fleet Bank headquarters, and the guy was able to show up at the branch and actually start, walking out with desks and stuff, to the merriment of literally everyone, because no one loves Fleet Bank. Even the people who worked at Fleet Bank, I think, were kind of embarrassed that they worked at Fleet Bank. But anyway, I mean that's the stuff of legend, but. Is it like district court where the minute you get that magic paper, the judgment, and assuming the person doesn't go into bankruptcy, which you assume in most cases they wouldn't over a small amount like that, then are your costs of executing said attachment, are those as collectible, enforceable as well?
They are, assuming you can collect the judgment, they are collectible. And don't forget, Pat, Rhode Island law attaches to any judgment that you obtain 12% interest per annum.
Right.
So, basically 1% per month, that's on top of the judgment. So as long as that judgment is out there and outstanding, it's collecting interest that you are able to collect. Right. So it could be, significantly more than $2,500 when all is said and done, if you have to go through all these procedures and that judgment remains outstanding.
Right. And so the pro tip here, if I can come up with it, and please correct me if I'm wrong, if you were on the wrong end of one of those judgments and you missed the appeal period, you're done. It's time to try and work something out. It's time to, as the late great Vincent A. Buddy Cianci would say, to come Coco, isn't it?
It absolutely is. And that's a lot of times when I have somebody call me up and say, I have a judgment against me in the district court. I'll ask them when that judgment was entered, and they will usually tell me it was entered 6 months ago or something along those lines. And then at that point, it becomes, let me help you work out a payment plan so they don't, wipe out your bank account, so they don't put a lien on your home, so they don't attach your wages, they don't garnish your wages, those kind of things. Those are the things you want to avoid, because then it's really out of your hands
Right.
as to how this is going to go forward. You want to be able to pay it on a schedule that is going to be not going to put you into bankruptcy, or is not going to disrupt your life as any more than it has to. So that's where a lawyer can help you in post final judgment procedures, is to work with the usually collection attorney that is now owning the debt that you probably owe, and work out of some sort of payment plan with the court, which any good collection attorney is going to make an order of that court. So when you violate that order of the court, you can come back and ask the court to adjudge the violator in contempt, which could lead to your incarceration at some point if you continue to flout the orders of the court.
Right, and that's the point I was ultimately getting to. I believe, is it called a body attachment? They can execute
Yes.
that where you're escorted into court under duress, if need be, because, and again, urban legend here. Tell me if I'm right or wrong. The constable at that point in time, does he or she have formal arrest powers at that point? If they've been that body attachment's been issued by the court?
Well, a constable would not have formal arrest powers. A sheriff would, or a local
Okay.
police department would. So what generally I've used in the past, and this is all part of typical civil procedure, is my constable will go to a debtor who's owed money, we've tried everything else, but has, for whatever one reason or another, refused to make arrangements to pay. I will send my constable out to them and say, listen, I have an order, after I've obtained a body attachment by the court, I will send them out that body attachment, and they will say, listen, I have a body attachment that's been issued by the court. You can either pay up or sign, an agreement that we all agreed to, that for a payment agreement, which will make an order of the court, or I'm going to have the whatever police come down here and drag you into court during court hours, and you're going to have to explain to the judge why you are in contempt of their order, why you're in contempt of that judgment, and why that judge should not incarcerate you until you come into compliance. And that
Right.
point, the judge can set some sort of surety bail, so to ensure your appearance, make you post bond, or there are a range of other remedies that the judge can do, depending on how serious the contempt is.
Right. So again, the point here is you've got a mechanism by which individuals can resolve their differences in a civil, in the sense that you're in a public hearing, as opposed to trying to cap each other out in the backyards. And I only say that with a slight degree of of humor, dark humor, as it were. This is Rhode Island. But the flip side of it is, once you enter this legal field of battle, it's real. There are significant issues at stake, despite the fact that it may begin only with a $500 or $1,000 dispute, which renders it all the more valuable to the individual pursuing relief. Is at any point in time, are you able to pursue municipalities or any agencies of municipalities? And I'm fantasizing here, but in small claims court, or are they largely have immunity from that type of engagement?
It would really depend on the claim. I'm trying to think of a claim where, a small claims court would hear something against a municipality or a local government, and with the possible exception of, to be honest with you, off the top of my head, I can't think of one.
Okay.
I haven't seen it. Possible exception, you may have a flat tire because there was a pothole.
I was about to bring that up.
Statutory,
Yep.
though.
Mm-hmm.
Yep, those are usually statutory, and those are things that if you make the claim to the municipality directly, those are things that usually get paid. So, I can't think of one that's going to actually make it to court.
All right. So in summary, if you will, barrister, $2,500 is the limit. Your court costs, and potentially your legal costs can be collected above that. You've got a once you're assigned a court date, you better be prepared to have be in a place where you're willing to give sworn testimony and/or have real documentation, because despite the informal nature of the proceeding, it is still a court, and you will be sworn in, and the rules of evidence apply. Largely corporations are not involved in these negotiations. They're designed to be individual against individual. Should you win, then you really leave from my impression, you leave, if you will, the small claims court environment, and you're using the same mechanisms that a district court would employ for you to gain relief, to receive your monies in return against a judgment. And at that point in time, you've got the full weight of the Rhode Island legal system behind you to collect your money. If the individual doesn't show up and there's a default judgment, can you get an appeal of a default judgment if you're within that 2-day statutory period?
You bet you can if it's out of the district court. At the district court, like I said, every judgment they make is appealable de novo to the Superior Court. So if you didn't show up for your date, your court date, the default judgment was entered, and you show up later in the day after the plaintiff was gone home, thinking that he or she has won the day, you can go to the clerk's office and file that appeal, and all of a sudden that judgment has been vacated. You are going to the Superior Court.
Wow. Again, it's seemingly simple, straightforward, innocuous in a sense, but yet, as with everything legal, there are complexities and nuances. Is there a point where you recommend getting an attorney? Will an attorney give you an hour paid time to, particularly if you're looking at something in the couple of $1,000s range? Is an attorney of value in that sense, and that they can, if they're not smart enough to listen to this show every week and essentially get a free legal education? That literally, when we look over the body of shows now, I think we're on our 12th show. You've given folks the opportunity to get an amazing legal education on an incredible variety of issues. That absent a couple times when we go into the bigger stuff, if you will, most of this show has been aimed at the very type of legal entanglements that a Rhode Islander can face. Again, small claims court, OUIs, DUI, weapons issues, criminal complaints, all of this. Chaz, I got to tell you, it's incredibly valuable stuff you're giving folks here. But at what point, and just sort of in closing, does it make sense to go see an attorney from your perspective?
I mean, if you really don't have the ability to present a case in court, or you just don't know how, or perhaps you just the whole process intimidates you. There are attorneys who do small claims, and they do a lot of them, so it makes sense for them to do it at a reduced fee or a fraction of the fee that you would normally pay an attorney to go through with a normal civil case. And like in my practice, I give everybody an hour of free legal consultation for any kind of case that I would potentially handle, and that may be enough for you to go walk into your own civil case or your small claims case and do it yourself. I certainly think that the legal education that I'm providing people on this show is worth more than the $200,000 that you probably pay at any kind of law school these days. So you probably learn more from 1 hour with me than you will at Harvard Law School. And I'm not floating my own boat there. That's just a fact, because
Right.
what they teach at law school these days is garbage. So that's what you do. Most attorneys do offer a free consultation. A lot of the attorneys who will appear in small claims court do a lot of them. So
Right.
if you have a particularly difficult claim where you may have some evidence that you have to authenticate, and you have to kind of use the rules of evidence to get your claim across, that's when I would suggest you probably go to an attorney. And I want one more important point, Pat, before we end the show here. The one difference that, and I mentioned it earlier a little bit, the one difference that you're dealing with as a plaintiff in small claims court is you better win because you've signed away your right to appeal if you lose, which is not the case in any other civil case.
Wow.
Only in small claims court has the plaintiff signed away your right to appeal. So if you lose, that's the end of the game for you.
Wow. Well, Jazz, great stuff. Again, we're minus the politics. We're long on information for folks. A lot of this that you've given us over this, 12 episodes, I'm not aware of any other place where you get this type of information. So many of the law shows, and there's some great law shows out there, but they're focused more on the dramatics, the murder cases, the celebrity cases, and whereas your focus on this in this effort continues to be at a sort of a ground floor level, practical issues, legal facts, actual practice issues as they affect individual Rhode Islanders in their sort of day-to-day lives. And I'm not aware of anybody that has gone through a life well lived without running into some sort of entanglement. It's just particularly in a place like this, it's part of the landscape, isn't it?
It certainly is, and it can be a very intimidating one. And I think that I'd like to do this kind of public service because I'm looking for a better Rhode Island. I'm looking for a Rhode Island that has more access to the courts. I'm looking for a Rhode Island that has more fairness to the courts and have people who are able to seek redress for any sort of wrongs that they face. And this is a system where they have that potential to do that without having to break the bank.
There you go. Well, take us home, Counselor.
Well, it's another one of our editions of Chaz Calenda, Attorney at Law. As I mentioned at the top of the program, I'm an attorney at the law firm of Inman and Torgy, and that's at 1500 Nooseneck Hill Road in Coventry, Rhode Island. You can reach me at 401-823-9200 if you're looking for representation. I focus mostly in criminal defense law, some civil litigation, some family law, and a few other areas. But mostly this is what I do, and I'm here to help you. We offer free consultations, and I also happen to be a candidate for the 2022 Attorney General race. So I hope you'll check me out at CHAS, CHAS, the number 4AG.com, and see that I'm running to be the Attorney General next year, where I'm looking to always put the law above politics. Pat, I'd like to thank you again as always, for your amazing insight that you always offer us and your wonderful banter that we can go back and forth here and do every Wednesday. And I look forward to having the opportunity to do it with you the next time.
Excellent.
And thank you all for joining us here on another episode of Chaz Calenda, Attorney at Law. Hope to see you on the next edition. Have a good Wednesday night, everybody, and I'll see you later.